Hey, how we doing today? I want to talk about estate planning is and mistakes you can make is earlier this year my parents passed away. It wasn't it was a bit sudden. It wasn't, they were in their mid 80s. It was, you know, expected to some extent, but jarring nonetheless. But my dad worked for a trust company in Boston, managed assets, did estate planning, all of that, kind of what we do, but on a more corporate scale. He worked there for, I don't know, 25 years. And I am dealing with his estate plan right now, as the trustee and executor and all of that. And I feel like the cobbler with kids with no shoes. I look at some of the things he did that he knew better and didn't get taken care of. Some of it we knew between when my mom passed and he passed. We were trying to take care of it. He kind of left a little early. Um, but yeah, so I want to talk about estate planning mistakes because one of the things I do know after doing this for 30 years is I can tell you based on someone's attitude in our first meeting about estate planning if they have had to deal with settling someone's estate. Because if they have, they are very particular about what they want done and they are very on top of it. And the ones that are a bit blasé have never had to deal with this. And I don't think they'd want to hand these problems to somebody else. So that's what we're going to talk about today is not handing those problems to somebody else because it's not you that's going to be inconvenienced uh, by your estate planning mistakes. It's going to be your kids. And most people look and they go, I don't feel like putting that burden on my children. So let's talk about 5 things that I found that you should be thinking about when dealing with this. So the first one is have a will. Everybody needs a will. Just about everybody needs a will. If you're over the age of 25 and you have some sort of assets, you probably want to have a will. And the will just says, if I die or when I die, and my assets don't know where to go because they don't know where to go, this is what I want to have done with them. Because the alternative is to die what's called intestate, intestate, uh, which means you don't have a will. And who gets to decide? Thankfully, there's not a huge court battle, although that does happen. Is back in the prior century for sure. You look at like the Elvis Presley estate was in all sorts of turmoil for decades. A lot of famous people just did a poor job of managing that. But if you die with no will, as opposed to a contested will, the state actually gets to decide where your money goes. For the most part, if you have a spouse and children, the assets in most states, for the most part, will be split between them equally. Most people are very surprised by that, as your spouse does not inherit everything automatically. Your children do inherit that. Not always a big deal because a lot of assets in a marriage are jointly held. But somebody who is single, maybe it's going to start going to the next nearest relative. I had a situation about 8 or 10 years ago with a client who had a cousin he didn't know about, and he wound up being the executor because he was like the closest living relative and had to deal with settling this estate, which we did. We helped them out. We connected him with an attorney and were able to settle that estate. But it was kind of a hassle because there was no will and it was up to these laws of intestacy to determine that. So make sure you have a will so that the property you own goes to the people you want. Second one, this is very specialty, is most people over the age of 50 that get some sort of full estate plan will have something called a power of attorney. Power of attorney just says, if I can't make financial decisions for myself, I appoint somebody else, usually a spouse first, usually a child or a close relative second, to step in and make those decisions for me. So for instance, you're in the hospital and we need to pay bills, move money from point A to point B, things like that, sell assets perhaps. If you can't answer for yourself, let's say you're in a coma, uh, it's important to have that power of attorney so that someone else can step in. Now, there are 2 different types of power of attorney. There is just what regularly is called durable power of attorney. Durable means it's durable, which means that if you're not awake, if you have Alzheimer's or dementia, it's still effective versus a regular power of attorney. Once you lose mental capacity, for whatever reason, the power of attorney stops. So a regular durable power of attorney appoints this other person, again, usually a spouse first, that has full power. If they hold your power of attorney, they have full power. They can sell your house out from under you. They're allowed to legally. And that scares some people. So they'll typically name their spouse with full power, but they will do something called springing power for their children. And I will caution you on this. It's that nobody has a crystal ball, but with a springing power, you will need a doctor's note in order to step in that they're not capable of answering for themselves, which may not be great if you need to do things quickly. Doctors don't act quickly. Lawyers don't act quickly. That springing power is there to protect you so that, if you end up with an evil stepchild that steals the power of attorney from your safe in your house and goes off and sells your house, it protects you there. But the chances of that happening is actually pretty small. I mean, if you trust your kids, you know who your children are, I think better than anyone. For many, many years, I advocated personally that, yes, springing power is great. I'm not so sure anymore. I think it's really an independent decision that somebody has to make. And if you're sitting down with an attorney and the attorney says you have to do springing, look at your children, look at where they are and how much that you want to put on their shoulders before you make that decision of springing power or not. Because sometimes, in my dad's case, he was in the hospital for 3 or 4 days before he passed away. And there were things I wanted to get done. It wasn't a big deal one way or the other, but it would have been handy if I had the power of attorney that wasn't springing and his was springing. So be aware of that. The third one, I've only seen this twice in 35 years, but make sure of it. Name beneficiaries on your IRAs, 401ks, 403bs, life insurance. Don't list your estate as the beneficiary. I had 2 cases where with an IRA and a 401k, someone listed their estate as the beneficiary, which is like the worst thing you can do. It was atrocious. It was awful. In both cases, it created all sorts of mess. It caused an $80,000 tax bill in one situation, which was bad. It caused all sorts of family rifts in the other, as we had to probate the whole estate just to be able to get access to the money. And all of the relatives were sitting there, like Snidely Whiplash, trying to get their mitts on it. And everybody was frustrated that the estate owed income taxes on this money, and everybody wanted somebody else in the family to pay it. It was awful. It was awful. I could not believe how a family devolved so quickly just for some money. But naming specific beneficiaries and naming contingent beneficiaries is vitally important. It will save you your beneficiaries countless hours. It will save thousands and thousands of dollars, not just in probate fees, but possibly in income tax costs as well. So be sure you make sure of that. The fourth one is make sure you put the right people in charge. And there's a lot of aspects to this. Is the first one is naming, say, an executor or trustee of your trust. It's not a popularity contest. It's not fun. I'm dealing with the stuff with my dad's stuff right now. It's not fun. It's not glamorous. It's a pain in the patoot, and it's slow and it's time consuming. It takes up pieces of your day. A lot of times people will say, well, I'll pick the oldest. Those days are gone. I remember my wife's grandparents did that, and they named their oldest as trustee, and it was a colossal disaster. It was known that there was going to be family disagreements because of it, and there were family disagreements because of it. My wife's grandfather, who I loved, the pop was the best. Just couldn't. He was of a generation. He couldn't. He had to name the eldest son to be the trustee, because that was what you're supposed to do. You don't have to do that anymore. You want to be careful naming multiple people concurrently. Some attorneys love it. Some attorneys hate it. It can get sticky. So naming both of your children, say, I would like them to act together. Well, what happens if there's a disagreement of what to do? Who gets to decide? Who's the tiebreaker? Things of that nature you want to be very careful of. You want to look at if you're under 70, I would say when you're picking, especially executor or personal representatives, what's called now, trustee, power of attorney, you may want to pick a peer as a first level. So a peer. So, outside of your spouse. Spouse is always first, obviously. But beyond your spouse, you may want to, depending on how young your children are, but definitely under the age of 70, probably under the age of 60 for sure, you want to name a peer, brother, sister, cousin, somebody of your age group first. And then name somebody of the next generation, child, niece, nephew, second. Here's why is you may have a 20 something or a 30 something child and something tragically happens to you. That child is dealing with all of that, plus trying to build a family and everything else that goes on with being of that age. Having somebody of your age group take over those responsibilities might be very smart. Now, let's say it's 20 years later. You've kept things the same. You haven't updated your estate plan. Please update your estate plan regularly. But let's say you didn't, and you pass away, and now your child is 40 or 50. Much better place to handle that for you. And whether that brother, sister, cousin is still alive or not, if they aren't, not a big deal. And if they are, they can always resign as trustee, executor, power of attorney, and leave that to your child. So it allows you to have the best of both worlds, is to protect your children, your adult children, young adult children, while they're still young adults, but make sure they step in. The last thing is picking the right person. And I'll tell you a quick story on this. This has got to be at least 30 years ago. First time we sit down and do estate planning with my parents. We are sitting in the attorney's office, and it's me on the right, my dad in the middle, and my mom on the left. And my dad was 6'3", 6'4". He didn't quite fit in any chairs. He was always hunched down. His knees were like above his head type of thing in most chairs. And that's how he sat. And my dad, my gosh, if a 30-page essay was required to explain something, he would give you 2 words. That was just who he was. He just was not a man of many words. When he had the words, my gosh, he was brilliant with them. But he held, it wasn't necessary to speak. So the attorney says, do you know who you want to be executor? And he just points to me, just gives me this left, this right thumb point. And I knew that. She's like, now what about trustee of your trust? And he points to me again. Not a word. What about power of attorney? He points to me again. And she says, what about healthcare proxy? And he points and I went, hold on. And leans over beyond my dad is my mom with this tear coming down her eye of how could I say no to be healthcare proxy for them? What that does is it's a type of power of attorney, if you're not aware, that says if I can't make medical decisions, I appoint this somebody else to take care of it. And I sat there and I said, Ma, I am not the person to do this. I'm not the person to do this. At that time, I was 32, 33, something like that. My belief was, I'm going to keep you alive as long as possible because I don't know how to deal with this decision. And if you don't want that, do not pick me. At the time, pick my brother. My older brother was in healthcare, much more further along. He's 6 years older than me, so much more further along in his life, understood things, was able to listen to them better. He's a better choice at that time. So you don't have to pick the same people all of the time, is you can pick and choose. So your healthcare proxy may be one of your children if you have multiple children, and your trustee may be a different one, and your power of attorney may be a third different one. So power of attorney, keep in mind, for the most part, is things like paying your bills. Let's say you're in a nursing home or assisted living and you need somebody to step in and pay the bills. They can step in and pay the bills. So be aware of that. Okay, one more funny story. Dealing with all of that and making decisions is it's about the same time span. And one of the things that was brought up was what's called a living will. Living will is not enforceable in Massachusetts, but it's nice to have. Living will says, if I have these awful medical conditions, either keep me alive as long as possible or let me go. Pull the plug, as they often say. And my dad had this brilliant idea to bring this living will to his mom, my Nana. And my Nana was awesome, but my Nana was the most Catholic person in the world. It was frightening. Is if the Pope said so, that was okay. And if he didn't, you can't do that. That's just how she was. She was just very like that. And it was one of the big things back in the 80s and early 90s in Massachusetts was this whole living will thing. We had a couple of court cases at that time. One of them was the church we went to, Holy Cross Church in Easton. One of the members there was a firefighter and was being kept alive. And there was a question of could they take him off life support and all of that. And it was like a Massachusetts Supreme Court case on all of that. So it was front and center in Massachusetts. And the Catholic Church kind of took a position of you can't mess with what God's doing. And my dad knew that, but he went in anyways. He's telling me this story afterwards. And my grandmother was she was brusque. She was a pleasant person. She was lovely. If you knew her as a friend, she was lovely. If you were inside the family, she was a bit brusque, but it was just, it was a defense mechanism, I guess. So he went and he's like, okay, Ma, we got this form that we can fill out and kind of know what your wishes are. And she's like, oh, okay, that sounds good. That sounds good, buddy. And, and he says, well, if you have this and a feeding tube and this, do you want us to keep you alive or do you want us to kind of like pull the plug? And she looks at him like he's got four heads and says, keep me alive. Oh, okay. And he goes to the next, and it gets progressively worse and worse. And she is getting progressively angrier and angrier with him. Till finally he goes, I think we're all set. And he closes the thing and leaves. And my gosh, me and him laughed and laughed and laughed that night. He says like, yeah, because he said, I was over like that night. He's like, yeah, because your grandmother told me this story. So it's important to know what people's wishes are. It's very important to know what their wishes are. But pick the person that can make sure that they're carried out correctly. So the last one, and kind of the one that I designed this whole episode on, is funding your trust. So often people create living trusts and don't fund them. And that was my dad's situation. Was they owned two separate condos and neither of them were in the trust. Now I wouldn't mind, but the last three houses they owned were in the trust. For whatever reason, the attorney said, man, I really don't want to do it that way. You can fix it afterwards when he's closing. And my dad was too nice of a guy that said, oh, okay, and never fixed it. And after my mom passed away, it was okay. And we were selling them. That was the thing. We were selling both of them. So it was like, we're not going to worry about this. We're going to just not worry about it. He was going to go into senior living. We'll just sell them and just move on, Dad. It's not a big deal. And then he passed away. So they were not in his trust, and we're dealing with a probate issue because of that. But I'm not telling you that story. I'm telling you a different story today of why you should fund your trust, because I'm on the case and I will work my pants off to keep the costs low. This was a situation where this client got absolutely railroaded. So this is going to be 20, 25 years ago, sitting down with a new client, Bill. And Bill had a substantial estate. He had a very large house that at the time was worth $1 million. And among other assets that he had and that were taken care of. And I look, and Bill attended a prestigious university, and it was a big deal. It was probably the first professional that dealt with him that didn't attend said prestigious university. Don't know why that was. It was important in that era. He was probably born in the 1920s, 25, 28, something like that. It was important when he was going to college in the 40s. That was a big deal, and the camaraderie, and I will deal with, a Baird man and all of that was necessary and important, and not so much today. So I'm looking through all of his financial paraphernalia, and I find just pieces of trusts for him and his wife, and they are just all over the place. I've got the original trust for him. There's like 4 addendums to it. They're changing beneficiaries or changing trustees, things like that. But the first trust was written 30 years prior. There was never been a restatement of the trust. A lot of times an attorney will restate a whole trust. As opposed to drafting a new one, they'll just restate it because you've funded the trust, because you've put assets in there. We'll talk about what that means in a second. And I said, gee, Bill, maybe we wanted to get this updated because this stuff is, it's on vellum. It's old enough that it's like ancient. This may be closing on an antique, and we haven't restated it. The laws have changed enough. We might want to get this taken care of. Well, I'll talk to my attorney. I said, I have attorneys we can work with. No, you don't understand. I deal with Jonathan Pimplebutt, and Jonathan Pimplebutt was a classmate at Baird, and it's very important. Oh, okay. Talk to him. So I get a phone call from Bill a couple weeks later. He's like, yeah, we need to go meet with Jonathan Pimplebutt in his office in Boston. Okay. Are you free on this time this day? Yep. I'm taking the whole day off because I got to drive into Boston from South Shore, get to find parking, park the car. And this is 25 years ago when it was a little bit easier to do so than today. I couldn't imagine it today. Go to this high rise, very prestigious law firm, go up to the somethingth floor, and go into Jonathan Pimplebutt's office in this corner office, beautiful office, to sit down. None of that intimidates me, even though I'm 30 something years old, and Jonathan Pimplebutt is 62, 65, something like that at the time. And he says, so, what's your concern? I said, well, my concerns are twofold. I said, one is, this trust is like an antique. The laws have changed. I think it's important for us to do a restatement just to kind of get it together. Maybe we just want to draft a whole new trust. There's nothing important. Nothing's in this trust. Nothing's been placed in the trust. We don't need to keep this 1972 or 1962, whatever it was, trust. We can just draft a whole brand new one and make it pretty and make it clean and be done with it. He's like, no, I'd rather do the restatement. I said, okay, that's fine. That's not a big deal. What's your second concern? I said, there's nothing in the trust. I said, we need to fund the trust. Now, that's probably the most important thing. He said, well, why would you do that? I said, no disrespect, but the time and cost it's going to take to probate Bill's estate is insane. And at the time, 25 years ago, it was a year to probate. And we'll talk about the costs in a minute. I said, if we take just the house and we take the house and we place it inside of Bill's trust, we can avoid all of that. And what that means is just, if you're not familiar, is just retitling the house in the trust name. Now, Bill and his wife were trustees of the trust during their lifetimes. It would have been very easy to take care of all of that. And Jonathan Pimplebutt said, you don't understand, is Bill and I are long, long friends, and this firm will take care of Bill when the time comes. And Bill's nodding his head, and I'm thinking, there's nothing I can do. There's not a thing I can do. Okay. Now, Bill thought like taking care of, like holding a baby and rocking. Unbeknownst to him, and I don't think he meant this as maliciously as I'm going to say it, but it's the truth. What Jonathan Pimplebutt meant was as a mafia hit. Is there was no way when Bill was gone that anybody was going to honor anything ever again. And about a year later, Jonathan Pimplebutt retires, and his assistant takes over his practice within the firm. And about a year and a half after that, his Bill passes away with the house still in his name. Not in him and his wife, because they had split the estates and all of it. There was a whole bunch of hullabaloo that the attorneys were doing to make it more complex than necessary, to make it seem like they were very important, and they weren't. It was a year. And I will tell you that year, I spent 80% of the time of all of the hours worked. I spent 80% of them doing all of the work to get everything settled. The attorney at, the prestigious law firm in Boston did very little work. She would call me, have me do the work. And in the end, Bill's widow wrote her a check for $40,000. And that is just criminal. And I said, yeah, I don't think we should pay this. She's like, I just want to be done with it. I just want to be done. I know they don't deserve it, but we're just going to move on. And that bugs the heck out of me, because I know if Bill could come back from the dead, he would march right down there and tell them to stuff their $40,000 bill down their throats. How about 5? How about 8? $40,000 for doing literally not much work. I did most of the legwork. They had to, look up a deed, rewrite a deed, and have his son sign the deed. Was the extent of the amount of work they really did, and prepare a couple of tax returns. That was it. It wasn't 80 hours of work. They didn't spend 80 hours of work in 2 years. They just did not. So that is probably the biggest thing I can give you as a takeaway. If you do not fund your trust, if you do not if you create this living trust and you sit there and you take it, and a lot of times it'll have that fake leather binding on the binder, and isn't this great? And you put it up on the mantle. If you don't fund it, it's useless. All of the work you just did, all of the money you just spent, whether it was $2,000, $3,000, $5,000, $8,000, you can just flush it down the toilet because it's not going to help. You're still going to go through probate. You are still going to pay all those costs, and it's not going to help your family at all. And again, how I started this, I can tell you from the very first meeting with a new client, whether they've dealt with this or not. Because if they do, they will never, ever do that again. They will not do that to their children, because they look and they say, the reason Bill's widow was okay was it was just under the $40,000 to her. It's just not worth it. It's not a big deal. Yeah, it is. It is a big deal, because if Bill was there, he would have fought for it. And it's just whoever inherits, they'll allow somebody to take advantage of your loved ones. And whether it's the state, the feds, an attorney, some investment firm. And I've seen that recently. I had a situation where they'd complete aside that there was a corporate trustee where this law firm, legal accounting firm, I forget, was trustee for this trust, and they sat on it for 4 years to just pad their fees. Criminal, absolutely criminal. There was no reason. It was so cut and dried. Don't do that to your children. So I hope I scared you just a little bit. That was my goal today, is to kind of put a little bit of fear of God, as we never want to deal with estate planning, but it is a vital thing for us to do. It is important for our loved ones, our children, our grandchildren, to make sure that we have a good estate plan, that it's properly reviewed on a regular basis, and executed well, so that the assets that you have worked hard to accumulate, if you don't get to spend them all during your lifetime, it goes to the people that you want, not the people you don't want. Have questions? Jump down in the show notes, reach out to us through our website or through social media, and we can see if we can help you out. Stay safe out there.
Thank you for listening to our podcast. Remember, the views expressed are not necessarily those of Successful Money Strategies. All content is for educational purposes only and should not be construed as an endorsement of any third party or their views, or as a solicitation or offer to sell securities or provide investment, tax, legal, or consulting services. We believe the information presented to be reliable, but it is not guaranteed for accuracy or completeness. Investing involves risk, including the potential loss of principal. Hypothetical returns do not reflect actual trading and may not be indicative of the performance of any specific investment. Always consult with a qualified financial advisor before making any investment decisions. Past performance is not a guarantee of future results. Additional information, including management fees and expenses, is provided on our Form ADV Part 2, available upon request, or at the SEC's Investment Advisor Public Disclosure website, https://advisorinfo.sec.gov.